Hello for everyone that was not able to attend today, so I wanted to put a little bit of a video together for you. What I wanted to discuss today were basically two areas. We just got done going through contract law, and I wanted to cover a little bit of what actually we need to be able to do some piece of business to bring in some goods, some services. So I want to play two short videos. One has to do with something called the inks. It's not ink as in pens. It is basically the criteria that we use in shipping, because what we're most interested in is the idea of, for example, landed cost. So when I did factory automation and robotics and things like this, it was the idea that, well, okay, so if I were to purchase this, for example, in Japan, there's a certain number associated with that, given a rate of exchange between dollars and yen and so forth. But then in frictions, we have insurance cost, we have shipping, we have, et cetera. In finance, we call it frictions. So we have all these frictions. So sometimes it's just easier to make a deal that says, hey, look, I'm interested in whatever this factory automated system, robotics, whatever it happens to be, but I'm interested in the landed cost. Well, that would kind of indicate one or more of these different areas. And most frequently, the one I used was FOB. And it means free on board, and you could do some independent research. There's plenty on Google and so forth, but basically it was FOB, for example, the Port of Long Beach, California, which is the Port of Los Angeles. And landed cost would include the idea that FOB, Port of Los Angeles, add to that tariffs, add to that shipping costs. So in other words, when a truck goes in to pick this machine up, or these robots or whatever it happened to be at the Port of Los Angeles, what is the landed cost? And FOB was a part of that. So I want us to get a little bit familiar with some of the terms. Let's see if we can get through this. It's about 8 minutes, a little bit more than that. And then I have an even shorter one on something called a UCC-1 form. UCC, Uniform Commercial Code, and the UCC-1 is basically a security. But we'll talk to that in just. Let's see if we can get this one.
This is presented by HPS Trade Yapa and Freight Forward in Thailand. This time let us explain about ink to understand very well. Ink is the trade term and condition, and it describes 3 English letters such as CFR and FOB. There are 11 kinds of Incoterms in total. It is not easy to remember all 11 kinds of Interms, but please do not worry. As a beginner course, let's focus on 6 kinds which are used very often. It's okay to remember the rest of the others after remembering those basic 6 kinds of inks. First of all, what is inks? We need to understand this first. In trade terms and conditions, inks is clearly mentioned who pays the freight in the different steps of the cargo delivery and who has the responsibility for those cargoes in the different steps of the cargo delivery between sellers and buyers. Please, understand those 2 points first. As international trades, there are different steps and procedures for the cargo delivery. Through those steps, we decide to mention in terms about the range of the money payment and the timing of the cargo when the cargo true deal. As long as both the seller and buyer do not recognize and follow the clear rule MUT for avoiding the trawlers, and buyers must make deals based on the international rule. Time will be basic in terms of which are very often in trade business X FOB CFR CDDP. These 6 are today's TOEIC. Let us explain one by one. First of all, it's
Ryder has been growing at an astronomical pace, not only the employees, but also the number of customers.
Its X is also called X Works as well. Sellers pass the card to the buyers at the factory in exporting. Buyers and make all pay such as transportation fee from the factory to the delivery places, and importing the responsibility of the cargo is moved from the seller to the buyers as soon as sellers finish to load the cargo from the factory to the containers. In other words, X works as the easiest trade for the sellers. Next, FOB is the trade terms and that the responsibility of cargo moved from sellers to buyers after the cargo are on the bow of exporting side. Sellers pay the local transportation fee in exporting side. Buyers pay the ocean freight and delivery fee in the importing site. In this terms and conditions, the next is CFR. CFR is used to call as cost and freight, but CFR is the correct word. In CFR, sellers pay all freight cost from the factory at exporting sign to the port and import. Pay the rest of such as shipping fee and transportation fee from the importing to the delivery place. Before talking about the movement of the cargo responsibility in CFR, let us explain about CIF. CIF is the same as CFR. Sellers pay all freight cost from the factory at exporting side to the port and import side, the different. Point between CFR and CIF is an insurance in CIF have ins cargo deli or about the cost and cargo responsibility CFR and C. In both CFR and C the delivery cost is on exporters from the factory at exporting sign to. The port and import side, however, the responsibility of the cargo and handling the cargoes are the same as FOB. Those are moved from exporters to importers. Please, in international logistics, the cargo is handled by the crane swinging in the vessel and then it takes a long voyage time to be delivered to the importing side in the container vessel. There are other containers with dangerous cargoes. We have sometimes heard about the story that the dangerous cargo was on the fire and the fire burned out the other containers. Unforeign, no one does not guarantee for the cargo. If you don't get the cargo insurance, we will so much secure as we get the insurance. No one knows what happens in the international logistics. We strongly recommend to our customers to get the cargo insurance every time. Let us back about Inc. One is DA is the trade term and that sellers pay to take together. DDP is the same as sellers arrange all logistics from the factory and exporter side to the specific delivery places and importer side. Seller exporter will take both delivery cost and cargo responsibility until the specific delivery places and import side. The different point between DAP and DDP is the payment of the import tax which exporters or importers pay for it. In DAP, import custom tax and consumption tax is paid by the importers. On the other hand, in DDP, sellers as exporters pay both import custom tax and consumption tax. Sellers will pay all transportation costs including taxes. Now look back about the cost and responsibility in terms of XWK is the trade term that importers will arrange all logistics from picking up the cargo at the factory and exporting places to the specific delivery places in importer side. Importers pays all the delivery cost until the delivery places and take responsibility for the cargo delivery. FOB is the trade term that exporters will arrange to pay the cost and take the responsibility until the cargo will be loaded on the vessel in the exporter side, and then importers will arrange to pay all costs, including ocean freight and delivery fee to the importing places, and the importers will take cargo responsibility as well. In CFR and CIF, exporters will pay all cost for the cargoes until the cargo will be delivered in the port of importing side. Importers pay local cost in importing side until the cargo will be delivered in the specific places. The attention point is the switching step of the cargo. Phobelmers car DDP XB cargo respility until the cargo will be delivered in Da pay the ties, but in DDP Express pay the ties. Payment of the cost is all list as like in Kirill all this. How is those about in terms of those inks are very often to be used most importantly. The decision of using ink terms is based on the agreement between sellers and buyers in all trade terms and conditions.
Okay, I think we'll stop there. Let me just see if I can do this. The other one I wanted to put up real quick.
So what is a UCC1 and how does it work? A Uniform Commercial Code Form Number 1 is a form creditors use to secure their interest in property. In that sense, a UCC1 form is to personal property what a mortgage or deed of trust is to real estate. So creditors use this form to secure collateral for loans, for example. Say John wants to open a gym and needs to borrow money for his gym equipment. The bank will generally record a UCC1 and describe the gym equipment that secures the loan. If John does not pay back the loan, the bank can seize and sell the gym equipment to recoup the loan proceeds. Hi, I'm the business guy with Lawyers Limited, and the purpose of this video is to help you grasp the concept and see how easy it is to understand what the UCC1 form does. I've been in the asset protection from lawsuits business since 1991 and bring you my personal experience. Our company started in 1906. We have attorneys on staff and employees nationwide. And if you're watching this on YouTube, can you please help me out by clicking the like button below so YouTube promotes this video? You can enter your comments, and you can also click the subscribe button below so that when more videos come out like this, you'll be up to date right away. So this is to give you a very easy to understand roadmap so that you can understand how secured creditors use the UCC1 form. Plus, you'll really want to watch until the end because I will reveal a very special way to use the UCC1 to protect your assets from lawsuits. Now, commercial transactions in the United States, such as contracts and loans, are governed by the Uniform Commercial Code known as the UCC. All 50 states have adopted a version of the UCC. Now, under the law, there are two types of property. Real property, which is real estate and things attached to it, and personal property, movable property such as cars, computers, furniture, stock, jewelry, and intellectual property such as patents and copyrights. So under the UCC, when a lender gives a loan and the lender uses personal property as the collateral for that loan instead of real estate, the lender must file a UCC1 financing statement. Now, when one files this statement, it tells the public, as well as future lenders, that specific personal property has been pledged as security for an existing debt. So whoever properly files a UCC1 for the specified property has priority over that property. That means if the borrower does not pay the loan as agreed, the lender can seize the property to recuperate some or all of its losses. Once a creditor files this form, the creditor establishes a relative priority with other creditors of the debtor. This process is also called perfecting the security interest in the property. The UCC1 filing makes this type of loan a secured loan instead of an unsecured one. A UCC1 financing statement may also be filed in the real estate records by an organization that leases fixtures so that they can establish the priority of the lessor's rights against the holder of a mortgage or other lien on the real property. The UCC1 financing statement is the security instrument that ties the property on the left to the obligation on the right. So the creditor's rights against the debtor and the lessor's rights against the lessee are spelled out on the credit document, such as the promissory note or the lease agreement in the examples we're talking about here, and not the UCC1 financing statement itself. So you make a promise to pay money on one hand, and then on the other hand, you pledge the property as security for that loan if you don't pay it back. Now, what many people don't know is that a filed financing statement typically has a duration of 5 years from when it was filed before it might lapse. Some exceptions are if it secures a manufactured home or public financing, it lapses in 30 years from the date of the filing. There are also exceptions for mortgages and utility companies. Now, when it does lapse, the financing statement is no longer effective, and any security interest that was perfected by the financing statement.
Imagine planting an olive tree today.
Becomes unperfected. A secured party can continue their security interest for a further 5-year period by filing a continuation 6 months before the expiration date of the financing statement. By the way, if somebody grants you a loan using a UCC1 form to secure that loan, many times lenders do not automatically terminate the UCC1. So as a borrower, it is important to ask the lender to terminate the UCC1 after the loan has been satisfied. Once the process is complete, the state, or in some cases the county, returns a stamped copy of the filed UCC1 form to the filer, along with any other documents that may have been filed along with this document. I found that most experienced experts also recommend filing the obligation document, such as the promissory note or lease, along with the UCC1, but the filing process does not require it. Some people have the debtor electronically sign toward the bottom of the UCC1 form in the optional filer reference data section in order to make the form more of a contractual agreement between the parties and to avoid the requirement of an additional security agreement. Sometimes we use the UCC1 as an asset protection strategy. That is, we set up an LLC for our clients, preferably an international LLC. Then we record a UCC1 that is payable to that LLC. Then if needed, we have an international lender purchase the UCC1 and deposit the proceeds into an international account in our client's International Asset Protection Trust. We then, for a fee, can assign that UCC1 to a new lender. Now, that is not money that our client can run away and spend, as that would be too risky for the lender, but it does show the judge that the personal property is secured by a UCC1 financing statement payable to a true third-party lender, and the client's international LLC received the proceeds. When the client is in the clear, the lender can terminate the UCC1 along with the proceeds that the client received for selling the UCC1, so they simply cancel each other out and the property is free and clear again. Now, it's very interesting because when I did my first video on UCC1s, I got comments below that I didn't even consider before, and they mainly had to do with the straw man theory and their legal fiction. For example, one question is, do you have any videos on how to take full control over your legal fiction and access bond ties to birth certificates? Now, years ago, I had a pediatrician customer of mine, and he explained the thinking along these lines. He had paid an attorney tens of thousands of dollars to get billions of dollars he thought the government was hiding from all of us. So this group thought they could record UCC1s against the Capitol building and the White House and all kinds of government buildings and get money for themselves. So I kind of knew where the commenter was coming from. And here was my answer. I said, if this is relating to the straw man theory, I have studied actual case law. I have not seen such arguments survive the vast majority of actual court cases with real judges. Rather, I have observed such claims as more imaginary theories by fringe groups. The fringe groups tend to be devout followers and sincerely believe their theories. And I understand it. I don't want to pay my taxes, my debts, etc. So I'm going to create an imaginary person in my mind that is separate from me who really owes them. Now, in the courtroom, this theory is held up for properly structured corporations. That is, the corporation is one legal person and the owner of that corporation is another legal person. But it does not hold up in the real world when a person imaginarily separates themselves from themselves. So I would rather adhere to what I've seen actually work in front of real judges and real attorneys on a large scale, rather than theories that some small groups think should work.
Okay, so let me stop with that. The underlying, of course, is that, and I'm sure we've seen, or some of us have seen, videos of so-called sovereign citizens and all of that nonsense. And, you know, the gurus that collect these fees and bamboozle people into believing that any of this stuff is real, they make themselves a rather nice payday. And the dumb SOB that bought into this nonsense, well, you're out the money, and depending on the situation you get yourself into, you're in for a lot worse. But that's got nothing to do with what we're interested in. The legitimacy of a UCC 1 form is basically, as was pointed out, a security interest. So when we get into contracts, and we just got done watching some information on contracts and so forth, we'll be talking about a little bit more capacity and a few other things to be able to make contracts and so forth. But the idea so far is that, look, we're doing this piece of business overseas. We're interested in landed cost, and we'll talk a little bit about that next week. And then we're also interested in the security aspects of this. And part of that is the UCC 1 filing. The other side of that becomes letters of credit, standby letters of credit, and we'll start to speak to those things in the next week or so. And when we get together next, I'll speak to some of the practical examples because I actually did this. And we'll see where we go with that. But I just wanted to record some of this quickly because several people were not able to attend class either on Zoom or in person today. And I don't want you falling behind, so I want you to at least have this piece of it. Blessings to all. Have a great day, and we're done for now.